Good morning, everyone, and welcome to this webinar. I am Karim Mesran, and I'm the Senior Fellow for North Africa at the Rafik Hariri Center and the Middle East Programs at the Atlantic Council in Washington, D.C. I would like to thank for the help and the support the State Department Office of Global Criminal Justice, the United Nations Support Mission in Libya. I would like to thank the Atlantic Council team for their support in organizing and promoting this event. It's a very timely and important issue, and I would like to spend no time in talking about it. I just pass the floor to my friend and colleague Tarek Al-Majlisi for his thank him for having accepted to be the moderator to the event. Thank you very much all again, and I'm sure it's going to be a very interesting and timely and important panel that we have. Tarek, the floor is to you.
Thank you very much, Karim. And thank you for inviting me to be here today and to moderate this discussion. And so good morning to our hosts in the United States, and good afternoon to our friends and colleagues across Europe, Libya, and the wider Middle East and North Africa region. My name is Tarek Al-Majlisi. I'm a Senior Policy Fellow at the European Council on Foreign Relations, and I'll be moderating this highly relevant and very timely discussion on transitional justice and accountability issues in Libya. I'll try to set up things slightly, or just to frame this session before us today. But frankly, justice and accountability issues have been neglected to almost a criminal degree in Libya for far too long now. And I use the term criminal here because, firstly, I'm not a lawyer, unlike our two wonderful panelists here today. And secondly, much like with criminal negligence, neglecting this issue in particular can and does and has led to horrific violence, to deepening grievances, to an abundance of victims, and to further crime in the future. But despite all of this and all of these knock-on effects, justice and accountability issues are always relegated. They're always diminished. They're always compared or contrasted unfavorably when measured up to things like political processes, political bargaining, security sector reform, those issues which are seen as the big, important, dare I say, sexy topics that everybody wants to prioritize and to be involved in, usually to the detriment of justice and accountability. But nevertheless, as we speak, the Libyan political process that is ongoing, and what is this now, like the third one in 5 years. I lose count sometimes, and I'm supposed to be the expert in the room, but this process is failing just like those before. It's heaving, it's spluttering, it's stalling as it fails to traverse what are becoming, sadly, very familiar obstacles. So if there is something that we should learn from constantly repeating our political experiments in Libya, it's that without justice, there is no progress. At best, all we will ever get is a step forward in preparation to take 2 steps backwards. And without accountability, there is simply no mechanism for conditioning. No conditioning mechanism there to temper a new nation or a new state, or even this milieu of kleptocratic, power-hungry politicians that Libya is cursed with, into becoming something more akin to statesmen. And this is why I think that this event today is so pertinent, because as our current political process struggles, we have a fantastic array of speakers to tell us all how the absence of justice and accountability issues, both on the ground in Libya and at the high level in the diplomatic realm, play a central role in our current struggles, and how we may be able to utilize these issues to then help rework our process and ensure the success of Libya's roadmap and Libya's elections, and actually make them relevant to the population at large before it's before it's all too late. So on that cautiously optimistic note, I'm going to introduce our remarkable speakers for today. We will begin with some remarks from the State Department's own Undersecretary for Civilian Security, Democracy and Human Rights, Uzra Zaya. We will then move on to our brilliant panel, and unfortunately, Kamal Abu Bakr has been unable to join us today. And he will be missed, but this does also give us a great opportunity for kind of a dialectic and a split perspectives between our two speakers, who will look at the kind of the international level and then the ground level issues respectively. So after these remarks from the Undersecretary, we will move on to Saeed bin Arabiya, and I hope I pronounced that right, who is the Director of the Middle East and North Africa Program at the International Commission of Jurists. And he will kind of zoom out to the international dimension and talk about legal reform and the prosecution of international crimes. And then we'll move on to Marwa Mohammed, who is the head of advocacy at the excellent organization, Lawyers for Justice in Libya, who will talk about how to promote transitional justice and accountability issues on the ground in Libya. And following that, I will open up to the floor, where we'll hopefully have about 30 to 40 minutes for you all to ask all of your questions to our most wonderful panel and hopefully have a great conversation out of it. So without further ado, I would now like to hand over to Undersecretary Zaya for her opening remarks. Thank you.
Good morning, and thank you to our co-sponsors, the Atlantic Council and the UN Support Mission in Libya, for organizing this event. I'd also like to thank our moderator, Mr. Tarek Megherizi of the European Council on Foreign Relations. I'm pleased to be with you virtually to launch this panel discussion on transitional justice and accountability in Libya on the margins of the 76th UN General Assembly. Decades of authoritarian rule and instability have left Libyan society in desperate need of a stable system that can uncover the truth of the past and provide justice, reparations, and rule of law reform. Ensuring accountability for human rights abuses going back to the Gaddafi era is critical to the national reconciliation process. The United States shares the aspirations of the Libyan people: a sovereign, stable, unified, and secure Libya free from foreign interference. Libyans should be able to feel that their rights will be respected. Establishing a stable legal and institutional framework for transitional justice will allow Libyan society to move forward. The upcoming presidential and parliamentary elections hold the promise of a new era of stability, peace, and democracy in Libya. I reaffirm the United States call for all parties in Libya to make the necessary compromises to ensure that free and fair elections take place as scheduled. Whatever its composition, the new government will need to demonstrate its commitment to protecting the human rights of all Libyans and healing the wounds of the past. This will include building domestic capacity to investigate and prosecute those responsible for human rights abuses. History has shown that such accountability mechanisms have enormous deterrent capacity and help to prevent the recurrence of violence in the future. If pursued with transparency and predictability, such prosecutions will not only ensure respect for the justice system in the long run, but will serve justice to the victims of atrocities. To ensure accountability and justice, the government must continue to take bold steps to document crimes. This includes documenting killings and other abuses which have been uncovered in mass graves, such as those located at Tarhuna. It is essential that history be documented. Evidence must be carefully preserved and the full range of internationally recognized forensic standards and techniques applied. Libya's legal framework must also be strengthened to ensure a fair and effective criminal justice system that will protect the rights of the accused. This can be done by building capacity domestically to prosecute crimes. Certainly, there are capable and committed officials ready to pursue justice, but they need affirmation and stronger institutional support. Here again, the prospect of national elections in December and the formation of a lasting unified government are key. Meanwhile, we remain concerned that victims and others seeking to document the truth and ensure accountability for abuses are not being adequately protected. Credible threats to their life and safety continue. We urge those with authority to establish witness protection programs, a tried and true best practice, and to do what is necessary to curtail attacks against justice system actors, human rights defenders, victims, and witnesses. Since 2011, the United States has invested more than $850 million in Libya's development, security, and humanitarian needs. That includes efforts to strengthen the capacity, sustainability, and accountability of its institutions. We will continue to advocate for the human rights of missing and disappeared persons and support access to justice and services for their families. We will also seek to strengthen civil society engagement, which includes participation of women, persons with disabilities, and other marginalized groups at every step of these justice initiatives. Finally, we urge all Libyan leaders to support the renewal of the UN International Fact-Finding Mission on Libya, currently under discussion at the Human Rights Council. The mission should be granted unhindered access to all Libyan territory and continue its mandate documenting human rights abuses and violations of international humanitarian law. It is vital to identify those responsible for abuses on all sides of the conflict. The work of this independent mission is crucial for those Libyans seeking the truth behind the fate of their loved ones. We hope today's event will provide us with an opportunity to build upon progress already made to identify and address obstacles to Libya's pursuit of fair and equitable justice. The United States looks forward to our continued work with allies and partners toward that goal. Thank you.
Well, thanks again to the Undersecretary for preparing those remarks. And if I was cautiously optimistic, well, then the Undersecretary helped to do away with that caution and reminded us all of the potential impact of prioritizing accountability issues and how that can help, as well as some practical steps for advancing them in the Libyan case. And now, because frankly, you're not here to listen to me pontificate on these ideas, let me please move quickly to give the floor to Saeed, who can help build on the Undersecretary's remarks and to get our conversation rolling. Please, Saeed, the floor is yours.
Thanks, Tarek. Thanks for the introduction, and thanks to the Atlantic Council for the opportunity to address the issue of transitional justice and its role in ensuring accountability in Libya. Libya has experienced decades of systematic and widespread human rights violations committed under the former regime of Muammar Gaddafi and following the 2011 uprising. Many of these violations amount to serious crimes under international law, including war crimes, crimes against humanity, forced disappearances, torture and ill treatment, and extrajudicial executions. These violations have left the Libyan society in desperate need of truth, justice, reparation, and guarantees for non-recurrence. The Libyan transitional authorities have undertaken some initiatives to address this need, including through the adoption of law on the rules of national reconciliation and transitional justice in 2012, the law on Abu Slim prison massacre in 2013, the law on the establishment of the General Commission for the Search and Identification of Missing Persons in 2014, and Law 29/2013 on transitional justice. The law on transitional justice provides for the establishment of a fact-finding and reconciliation commission with a mandate to investigate grave and systematic human rights violations and to refer cases for prosecution. Despite its importance, this framework in particular the law on transitional justice, fail to provide for jurisdiction over serious crimes under international law, including enforced disappearances, rape and other forms of sexual violence, war crimes and crimes against humanity. It also fails to ensure that amnesties and immunities are not used to foster impunity. The independence, impartiality, and competence of the Fact-Finding and Reconciliation Commission is not adequately provided for. The scope of its mandate is not sufficiently clear, and its investigative powers are too weak to serve its purpose. 8 years after the adoption of the law is yet to be enforced. The Commission is yet to be established. This is mainly due to the situation of armed conflicts and political and territorial fragmentation that prevails in Libya. In such circumstances, international support for transitional process and accountability in Libya has been limited. It has been recently expressed in the Berlin Conference conclusions as endorsed by the UN Security Council Resolution 2510. This lack of support or timid support to the transitional justice process reflects the compartmentalization that's prevailed over approaches to solving the Libyan conflicts during the last 10 years, with the need for political agreement in one corner and the need for accountability in another, and with time showing again and again that overlooking accountability in the interest of peace has compromised both justice and peace. The UN-backed political process and the Libyan authorities must send a clear message to all parties that impunity will not be the price of peace and that stability cannot be achieved when state officials and members of armed groups responsible for past and ongoing atrocities are held to account. To achieve these objectives, the Libyan authorities should amend or repeal and replace the law on transitional justice. In so doing, considerations ought to be given to ensuring that the transitional justice process and mechanisms are grounded on three elements: the right to truth, the right to a remedy and reparation, and accountability for crimes under international law. International law accords to Libyan victims, their families, and society as a whole the right to know the truth about past and ongoing atrocities. Who ordered such atrocities, who committed them, and who was aware that they were about to be committed and did not intervene to prevent them. Irrespective of any legal proceedings, victims and their families have the right to know the truth about the circumstances in which violations took place. And in the event of death or enforced disappearances, the victim's fate. To enforce this right to truth, authorities should ensure that victims are able to initiate cases before the transitional justice mechanisms, clearly and adequately define the role of victims in the transitional justice investigations and decision-making, and ensure the full participation of alleged perpetrators in transitional justice investigations. And also the publication of existence investigations and the scheduling of public hearings. Both experiences of transitional justice in the Maghreb region, in Tunisia and Morocco, provided for such public hearings, contributed to the establishment of truth over past violations. The right to a remedy, and in addition to the right to truth, the transitional justice process should also be based on foundation grounds in the right to a remedy and reparation, which includes the possibility for victims to have access to a competent body to file a claim and to seek reparation for the harm suffered. Whether the Libyan authorities maintain or provide for the establishment of the Fact-Finding and Reconciliation Commission or the establishment of a new Truth Commission, safeguards should be provided for in the law to ensure that the process of establishing such Truth Commission is based on clear criteria and transparent procedures that guarantee the independence, impartiality, and competence of the Truth Commission. The members should enjoy whatever privileges and immunities that are necessary for their protection, and the Commission should have all the investigative and sanction powers required to carry out its mandates, to collect and preserve evidence, and to prevent and sanction persons that might impede investigations, either by intimidating witnesses or tampering with evidence. And it's important to highlight the role of such investigative and sanction powers in light also of recent experiences and transitional justice in the region, as I mentioned earlier. and the ability or the necessity for such truth commissions to have access to archives and files and relevant information in relation to institutions and ministries that are not used to scrutiny or accountability, including Ministry of Defense, Ministry of Interior, and other security and armed forces that are involved or have been involved in cases of human rights violations. The Truth Commission should also be competent to provide reparations that are proportional to the gravity of the violations and harm suffered by the victims, and that are tailored to the needs of the victims as appropriate. Such reparations should include compensation, restitution, in particular restoration of liberty, and the specific case of Libya is particularly important given the number of individuals who are arbitrarily detained either in official or unofficial detention facilities, satisfaction, rehabilitation, and guarantees of non-repetition. And relevant to the ongoing political process, these guarantees of non-repetition should include ensuring that the integration of officials and members of armed groups in the state armed and security forces is conducted through proper and adequate vetting processes and standards, to the exclusion of all individuals who are responsible for crimes under international law, the establishment of full and effective civilian oversight and control over security and armed forces, and introduction and enforcement of necessary rule of law and human rights reforms, including security reform, reform of the judiciary, the reform of the office of the prosecutors, and other legal reforms required to ensure that accountability is ensured, that the right of victims is protected, and that violations are not to be committed again. The Truth Commission should also be competent to refer cases to prosecutors and courts with a view to ensuring criminal accountability as a key component of the transitional justice process. Here, I need just to highlight 2 or 3 elements relevant to the criminal accountability process in relation to Libya. The general assumption has been since 2011 that because of the referral of the Libya situation to the International Criminal Court, there is no gap when it comes to criminal accountability. However, 10 years after such referral, there are only 3 cases that are open before the ICC when it comes to the situation in Libya. 3 open cases does not mean that there are no other investigations, but at least in terms of the number of cases that are open, it's just 3 cases. 2 of these 3 cases concern individuals that there are reasonable grounds to believe that they are dead. Suhaimi Mahmoud Khalid and Mahmoud al-Utfal. When the ICC declares these cases, when the ICC declares these cases to be closed, there will be only 1 case before the ICC involving Saif al-Islam Gaddafi. The case of Saif al-Islam captures some of the gravity of the violations committed in Libya before the uprising and during the 2011 uprising, but it does not reflect the scale and the magnitude of such violations. And the Secretary referred to the establishment of the fact-finding mission of the Human Rights Council and the importance of its work and role in collecting and preserving evidence of crimes committed in Libya. And that mandate should be renewed, and the role of the fact-finding mission is important in terms of collecting and preserving such evidence. However, the fact-finding mission is not a judicial mechanism, and the ICC has rather a complementary. There is a complementarity between the ICC and the Libyan courts, and primary responsibility for ensuring criminal accountability rests with the Libyan justice system. Libyan justice system has been unavailable, or the judicial remedies have been unavailable so far. The number of cases that have been prosecuted is very limited. It's the case 630-2012 involving the former officials from the regime that resulted on their sentences, and that was marred by fair trial violations. The number of other cases is really limited, and this unavailability of domestic judicial mechanisms is related to both legal obstacles within the system and the legal framework governing the work of the judiciary. And it's also related to practical obstacles in relation to the situation of conflicts and fragmentation at the political and territorial level. In addition to that, there are also well-documented cases of judges and actors of the criminal justice system being under attacks and who are being subject to attacks. In such circumstances, it's really important to highlight and to reiterate the role of the judiciary in ensuring accountability and providing for a judicial mechanism to ensure such accountability. Such a judicial mechanism should involve specialized law enforcement agencies to deal with the legacy of human rights violations, specialized prosecution units, and specialized criminal chambers. And one concrete relevant example in this regard is the experience of the specialized chambers in Tunisia that has been dealing with the legacy of past human rights violations in the country over the last 3 years. And that we are not sure yet, given the political circumstances in the country, to what extent it will be able to carry out its mandate. So the importance here of having this judicial mechanism is necessary to establish the right to truth, necessary to protect the rights of victims, necessary to ensure that there are enough safeguards for the non-repetition of such violations. And thank you for your attention. If there are any questions, we'll be happy to respond to them. Thanks.
Thank you very much, Said, for that fascinating overview of some of the legal difficulties and the international mechanisms being used and the framework in play, as well as the failings of it. Before we move on to Marwa, I just wanted to remind all of our participants here today that if you should have any questions for either of our excellent speakers directly, or just comments or questions on the general topic of transitional justice and accountability issues in Libya, please feel free to begin adding them to the Q&A function in Zoom. And yeah, then I will be able to queue them up once Marwa is done. And on that note, Marwa, please, the floor is yours.
Thank you, Tariq. And thank you, everyone, for joining us today. Good morning, good afternoon, from wherever you're joining. Just to kind of pick up, I think what I'll be doing is going in a bit more detail around what Said covered around the transitional justice, and I'll be talking about civil society and accountability from the ground. I am Marwa Mohammed, Head of Advocacy and Outreach at Lawyers for Justice in Libya. Transitional justice in Libya has always been geared towards amnesties and reconciliation, placing the full burden on the victims, mainly to forgive and move on. This method fails to take a victim-centric approach. It fails to offer victims the truth and justice and accountability they deserve, and ultimately, it fails the transitional justice process. Instead, the politicalization of transitional justice with amnesties is the general approach taken over the past decade, and it remains unsustainable. And frankly, this approach has failed Libya over and over. In 2013, hopeful and enthusiastic, the Transitional Justice Law 29 was passed. While welcomed and promising as an initiative, it's still disappointed on many fronts. As mentioned by my colleague Said, it was largely geared towards Gaddafi-era crimes, and Law 29 remained silent towards crimes committed by non-state actors during the uprising in 2011 and beyond. Law 29 also failed to factor in accountability, particularly for international crimes and gross human rights violations, including torture and forced disappearances, arbitrary deprivation of life, rape, other forms of sexual and gender-based violence, slavery, war crimes, and crimes against humanity, all of which are still very prevalent today in Libya and must be addressed. However, before Law 29 could even come to form, it died a very quick death in 2014, when the political maneuvering and escalation of violence eventually led to the breakout of conflict in June that year. The talk of transitional justice reemerged in 2015 with the Libyan political dialogue, but it also died quickly, along with a weakened LPA, a Libyan political, the Libyan political dialogue at the time, that once again favored political expediency over justice and accountability. In the 2020 roadmap for Libya, which was geared towards a comprehensive solution for the country, transitional justice was once again put on the table as a key priority. In its initial draft, the roadmap gave way to amnesties as the reconciliation and transitional justice process. But for the first time, a large consultative process with Libyan civil society, including youth groups, women's groups, activists, and community-based organizations, actually brought in a diverse and comprehensive voices to the process. It was then the pushback from civil society and these groups that ensured in the redraft of the roadmap that transitional justice would prioritize victims and gave voice to victims, and the language and provided language that is more in line with international standards, reading the launching of a comprehensive national reconciliation process based on the principles of transitional justice, and promoting the culture of amnesties and tolerance in parallel with truth-seeking and reparations. It may not be perfect, but it is only with the presence of civil society that offered a counterbalance to what would otherwise be a full-on politicalization of rights that victims' voices would have otherwise been lost. And this is not the only time that civil society has played such a vital role in Libya. In the deficit of the judiciary, as highlighted just now by Said, and other failing institutions, civil society has stepped up and played a fundamental role in filling the gaps and pushing back against the political current. Civil society has been documenting ongoing human rights violations. Civil society has been preserving the evidence for when eventually the truth does matter and justice will be a thing again. Civil society has also projected the situation when no one else was watching. Civil society has approached UN mechanisms, mobilizing interests and support around what was happening in Libya. In fact, it was the persistence and dedication of civil society that finally saw fruit with the establishment of the fact-finding mission in Libya in 2020, who in face of COVID and UN financial deficits will still present its first findings next week at the Human Rights Council. Civil society has listened to victims and amplified their voices by offering a platform to be heard. In a study conducted by our organization, Lawyers for Justice in Libya, that will be published later this year, we interviewed for a survey around 385 individuals on the ground around their perceptions of justice in Libya. Of those interviewed, nearly all rejected amnesties for past gross human rights violations and international crimes. Also, everyone we spoke with wanted to see accountability and justice upheld. More specifically, they wanted to see that